Good morning, students. I am Professor Sumita Parmar, the principal investigator for this subject of women's studies. And today, in our ongoing series on women and health, I will present to you this module. It is on women and disability, paper Women and Health, and it has been written by Dr. B. Subhashri from the Rural Women's Social Education Center of Tamil Nadu and Ms. Ditilekha Sharma from the Tata Institute of Social Sciences, Bombay. According to the census definition, a person with disability is one who has been certified by a medical authority as suffering from at least 40% of any disability. According to this definition, more than 2.68 crore people in India have a disability of some kind, and of this number, 1.5 crores are males and 1.18 crore are women and girls. But the disability sector disputes these statistics and contends that there are actually many more disabled persons in the country than the census reports. Even the World Health Organization of the UN estimates that the actual population of persons with disability may be much higher, especially in the rural areas where there is a lack of medical facilities. Since disability is not connected only with physical handicaps, as is explained later in the social model of disability, the dispute in figures is also due to a lack of awareness. Despite the Persons with Disability (PWD) Act existing in the country since 1995, and despite India being one of the signatories of the United Nations Convention on the Rights of Persons with Disabilities, there is a long way to go before persons with disability are accorded or ensured a life of dignity in this country. Now, women and disability. In the patriarchal context of our country, where women are seen as a burden, a disabled woman is viewed as an additional burden, since she fails to adequately fulfill her cultural roles as mother and wife. Women with disabilities are not a monolithic category, and their marginalization is based on other socio-cultural identities such as caste or class, religion, residential location, etc. So, if we want to understand their issues, it is essential to locate them within these plural identity markers to contextualize their situation. Anita Ghai in 2002 wrote that both the disability as well as the feminist movements have not adequately addressed the issue of disabled women in India. The meaning of disability in our country is embedded in the basic struggle for survival. The image of disability is either associated with a flaw or as a punishment of God, and it is seen as eternal childhood requiring continuous care, protection and charity. When there is still so much of a son preference in the country and daughters are seen as pariah dhan or as burdens, a disabled daughter is an additional load. Further, since the cultural stereotype values women only as wives and mothers, women with disability get excluded because of a denial of these roles. Even while feminist academia looks at disabled women as being doubly disadvantaged, it has to produce concrete action and rarely moves beyond tokenism. Besides the cultural contemporary constructions of disability in India, are focused on the Western medical models of disability rather than the social model of disability. Now, the medical model of disability understands the issue as an individual problem, where having impairment is understood as an individual's disability. Their condition is regarded as given and a constant factor in the relationship between themselves and the society with which they attempt to interact. When disability is understood from this perspective, policy makers try to compensate people with impairments for the defects in their bodies. Disabled people also internalize the notion that their problems stem from not having a normal body. The social model of disability, on the other hand, was created by people with disability themselves. This model understands disability as an unequal relationship within society, where the needs of people with impairments are not given adequate consideration. In this model, people with impairments are considered disabled because of the fact that they are excluded from participation in the mainstream society due to physical or organizational and additional barriers. As per the social model, disability has also been defined as the disadvantage or restriction of activity caused by a contemporary social organization which takes little or no account of people who have physical impairments and thus excludes them from participation in the mainstream of social activities. By this definition, disability is understood as a particular form of social oppression and focuses on the obstacles which prevent people from accessing equal opportunities in terms of education, employment and transportation. However, the social model of disability does not do away with the idea of impairment. Disability and impairment do not act independently. According to the social module, while impairment is largely constant, disability can ease or worsen depending on the environment. Therefore, if disability is embedded in the social structure, it would mean that disabled men and women occupy different social spaces, though they may overlap sometimes. But disabled women are doubly oppressed because disability works in conjunction with patriarchy, and therefore several gendered dimensions of difference among disabled people require recognition, analysis and theorization. Under the Constitution of India, people with disabilities have been guaranteed fundamental rights. India enacted the Persons with Disability Act 1995 in February 1996. This act aimed at equal opportunities, protection of rights and full participation of disabled persons. This law, for the first time in Indian history, spoke about the needs of disabled people. This act was a step towards ensuring equal opportunities for disabled persons and their full participation in nation building. It provided for both preventive as well as the promotional aspects of rehabilitation and covered areas such as education, employment and vocational training, reservation, research and manpower development, creation of barrier-free environments, rehabilitation of persons with disability, unemployment allowance for the disabled, special insurance schemes for disabled employees, and establishment of homes for persons with severe disability. The 7 disabilities it covered were blindness, low vision, leprosy cured, hearing impairment, locomotor disability, mental retardation, and mental illness. The rights and benefits of the law were extended to those people who were certified by a medical authority to be at least 40% disabled. There were several criticisms against this particular act. They were, disability in the act was defined in a very narrow sense and was posited as a monolithic category with undifferentiated experience. The PWD Act did not contain any specific provision to address the rights of women and girls with disability. There were no guidelines or deadlines for the authorities concerned to comply within the provisions of the Act. The focus was mainly on the socio-economic rights without paying heed to civil and political rights. Besides the PWD Act, there are 3 other laws that pertain to people with disabilities. These include the Mental Health Act of 1987, the Rehabilitation Council of India Act of 1992, and the National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation, and Multiple Disabilities Act of 1999. But the PWD Act is regarded as the principal and most composite legislation concerning people with disabilities. Since then, however, there has been a major shift in the disability discourse and the understanding of the rights of persons with disability, which has been discussed in the following sections. Now, on December 2006, the United Nations General Assembly adopted an international human rights treaty. This was called the Convention on the Rights of Persons with Disability. With 160 signatories and 160 parties as of February 2016, the convention has a preamble followed by 50 articles. Article 4 of the convention talks about the general obligations of the state parties. Under this, the state parties are required to ensure and promote the full realization of all persons with any kind of disability. They are required to ensure economic, social, and cultural rights of persons with disability. It also talks about representation of disabled persons in the development and implementation of legislation and policies. India ratified this act in September 2007. Significantly, Article 6 of the Convention talks about women with disabilities and acknowledges the twin-track approach required to address double discrimination. It has 2 points. First, the Article 6 lists the obligation of the state parties. The state parties are obliged to take measures to achieve formal, substantive and transformative equality for women and girls with disabilities. They recognize that women and girls with disabilities are subject to multiple discrimination, and in this regard shall take measures to ensure the full and equal enjoyment by them of all human rights and fundamental freedoms. Second, state parties shall take all appropriate measures to ensure the full development, advancement and empowerment of women for the purpose of guaranteeing them the exercise. They should also adopt effective education and awareness raising programs that inform about gender and disability, equality and the rights of women and girls in particular, and combat cultural stereotypes associated with women and girls with disability. The CRPD committee has observed 3 main subjects of concern with respect to the protection of women's rights and the rights of girls with disabilities. First one of these is violence against women and girls with disabilities. The second is restriction of sexual and reproductive rights of women with disabilities, including the right to motherhood and child rearing responsibilities. And last, intersectional discrimination against women and girls with disabilities. After the Convention on the Rights of Persons with Disabilities, the CRDP, came into force, the government set forth a new bill, namely the Rights of Persons with Disability Bill, to replace the earlier Persons with Disability Act of 1995. The Ministry of Social Justice and Empowerment set up a committee in 2009 to draft a bill to this effect. It came up with a draft bill in 2011. Then, in 2012, the ministry came up with a draft bill which was sent for circulation among the cabinet ministers and states, and some versions of the bill was cleared by the cabinet in 2013. In February 2014, the Rights of Persons with Disabilities Bill 2014 was introduced. The Rights of Persons with Disability Bill 2014 covered 19 conditions under disability. These were autism spectrum disorder, low vision, blindness, cerebral palsy, deafness, hemophilia, hearing impairment, leprosy cured person, intellectual impairment, intellectual disability, mental illness, locomotor disability, muscular dystrophy, multiple sclerosis, specific learning disabilities, speech and language disability, sickle cell disease, thalassemia, chronic neurological conditions, and multiple disability. The bill confers rights and entitlements to disabled people, such as disabled friendly access to public buildings, to hospitals, public transport, polling stations, etc. The bill also provides for guardianship for mentally ill persons. This was not covered in the PWD Act of 1995, but it exists under the Mental Health Act of 1987. It allows district courts to grant two types of guardianship. Limited guardian takes decisions jointly with the mentally ill person, and plenary guardian takes decisions on behalf of the mentally ill person without consulting him or her. It also lays down stringent punishments for violations of the provision of this Act. One of the biggest criticism that the bill has received is that it fails in its obligation to ensure the CRPD. This has particular implications for women with disabilities. The bill fails to adequately ensure the rights of women with disabilities, right to legal capacity for all persons with disability, rights of people who are forced to live in institutions without their consent, and the rights of disabled people to access public places. The bill is also inconsistent with other laws pertaining to women, such as the Medical Termination of Pregnancy Act. While the bill penalizes the termination of pregnancy of a woman with disabilities without her consent, it adds that the termination can be done without her permission in severe cases of disabilities. Since the bill does not define severe cases, it can be based on the opinion of any medical practitioner, thereby threatening the reproductive rights of women with disabilities. The Standing Committee has recommended that a subsection be created for women and children under the Disability Act. It has also suggested that the clause which states that the consent of the guardian is sufficient for terminating the pregnancy of a woman with disability without her consent be removed, as taking away the right of consent for these women, from these women, affects their dignity. There are other legal provisions. Some of the provisions of the Justice Verma Commission are sexual assault upon a person with disability is considered an aggravated offense. A counselor should be arranged to assist persons with disability in the identification of sexual offenders. A person with disability can record their statement at their own house. A monitoring mechanism for the safety and physical security of children, women, persons with disability, inmates of mental homes, and widows. Conclusion. The issue of women and disability needs to be understood in its specificity because in a patriarchal context, women are likely to face additional vulnerabilities. When women can't fulfill their social cultural roles and expectations, they are considered liabilities by their families. Vulnerabilities are further complicated by the intersections of their caste, class, and geographical location. In the absence of social security, the responsibility for nurturance falls on the closest female relative, causing an additional burden on her, which sometimes leads to abandonment. So it is evident that the issue of disabled women is a complex and challenging one. The positive aspect is that efforts are being made to address this issue. But it is also clear that there is a long journey ahead if we really wish to provide a fair deal to the disabled girls and women in our society. Thank you.